Welcome to the Deep Dive. Today, we are really strapping in for quite a complex look at a modern legal matter.
Yeah, it definitely got layers.
It's this case unfolding down in Fort Bend County, Texas. Starts in family court, but wow, it escalates fast. We're talking serious allegations, criminal conspiracy, federal civil rights violations.
And that's the key thing for you, the listener, to grasp. It's not just about the underlying custody stuff, which is obviously important, but the real story is the strategy.
Strategy and the weapons used. Right?
Exactly. The procedural rules themselves, they become weapons. And then there's this AI system, this legal vaccine that flips the script.
Okay, so that's our focus, this AI, this legal vaccine, and how it played into a critical 5-day window. We're talking Friday, October 10th through Tuesday, October 14th, 2025.
Right, because that's when everything hit a wall in the state system, a complete procedural deadlock.
And the plaintiff, Reynaldo Aguirre-Macano, he uses this proprietary software, this legal vaccine, to basically force a way out.
Deliberately, to force a specific procedural outcome that opened the door to filing this huge federal lawsuit. We're talking 42 U.S.C. Section 1983 violations. Major stuff.
So our mission today, track the legal moves, the, let's call it human obstruction, and then see how this cold, hard tech insight broke everything open.
Yeah, it's like getting a backstage pass to see data-driven legal strategy playing out in real time under incredible pressure. Very rare glimpse.
Okay, let's start in the 387th District Court. The big problem was time, wasn't it? These temporary orders.
Right. The judge made a verbal ruling back on September 11th, supposed to last just 60 days.
But by October 10th, a whole month later, still nothing signed.
Nothing signed. And you need to understand, this wasn't just slow paperwork. This was, well, it was a trap.
A trap? How so?
Because in Texas, you can't appeal an order unless it's signed and officially entered by the judge. So for 30 days, the plaintiff is stuck.
Living under a temporary verbal order.
With no way to challenge it. And meanwhile, that 60-day clock, it's ticking down.
So the delay itself basically kills the right to appeal.
Precisely. It neuters the constitutional right to appeal just by doing nothing. Calculated inaction.
And this all came to a head at that hearing on Friday, October 10th.
Yeah.
That was supposed to be about finalizing the orders, right?
Supposedly. But things got heated immediately. The opposing counsel, Morgan Hybner from Adams' law firm, she submitted this draft order.
And it was problematic.
Problematic is putting it mildly. It was 36 pages long.
36 for temporary orders.
Yeah. And according to the plaintiff, it was filled with fabricated stuff, things the judge never actually said in the September ruling.
Compared to what the plaintiff submitted.
His was just 1.5 pages.
Yeah.
Super concise, just listing exactly what the judge ruled.
Wow. The difference alone, 36 pages versus 1.5.
Tells you a lot about the intent, doesn't it? It looks like an attempt to muddy the waters, overload the record.
And the plaintiff came prepared not just to argue about the content, but about the process itself. He pointed out procedural violations.
Oh, yeah. He flagged 3 big ones during that hearing, trying to show this was deliberate obstruction.
Okay, what was the first one?
Improper notice. So, Hybner kept sending revised drafts. October 2nd, October 7th, October 9th.
Okay.
The rule is, if you change the draft significantly, you have to give the other side 3 full business days notice before the hearing.
And she didn't?
Nope. By submitting the final contested version essentially on the 9th for a hearing on the 10th, she blew past that notice requirement. Technically, the judge shouldn't have even considered signing it that day.
Violation number 1, bad notice. What was the second?
This one was pretty slick, procedurally speaking. The plaintiff formally objected to the lack of proper notice.
As he should.
Right. But the judge just ignored it. Didn't say sustained, didn't say overruled, didn't say denied, nothing.
Why is that significant, just ignoring it?
Because if the judge doesn't rule on the objection, it technically doesn't get preserved properly in the record for appeal.
I see. So later on, an appeals court might say, well, the judge never ruled on that objection, so we can't review it.
Exactly. It's like it never happened officially. Obstruction by silence. Very effective.
Okay, that's sneaky. And the third violation?
It's just flat out refusing to let the plaintiff speak. When he tried to object further or talk about the fabricated content in Hybner's draft,
The judge shut him down.
actively shut him down, which violates a pretty fundamental right, the right to be heard in court.
So looking at these 3 things together, bad notice, ignoring objections, refusing to hear the litigant.
It really paints a picture, doesn't it? It suggests the court wasn't just slow, it was actively using the rules against the plaintiff, weaponizing procedure to stall and block any path to appeal.
And the outcome of that hearing? The judge didn't sign anything then, did he?
Nope. He said the orders were heavily contested, which, I mean, yeah.
Understatement.
Right. And he set an in-person hearing for the following Thursday, October 16th, 9:00 a.m.
October 16th.
Yeah.
That date feels important.
Why? Because it guarantees more delay. It pushes any potential signing past the point where an appeal could be effective before those 60-day orders just expire.
So the state court effectively slammed the door shut, solidified the deadlock.
Yep. Mission accomplished for whoever wanted delay.
All right, so state court's a dead end. The next logical step is the appellate court, right? The plaintiff filed a writ of mandamus.
He did, immediately. And a mandamus, it's not a standard appeal. It's considered an extraordinary measure.
Explain that a bit. What makes it extraordinary?
You're basically asking a higher court to step in and order a lower court judge to do their job, a specific, non-discretionary duty.
In this case, the duty to actually sign the orders.
Exactly. Sign the orders so the plaintiff could finally file a proper appeal. You only file a mandamus when you think the lower court has seriously overstepped or just failed to act when legally required.
Now, here's where it gets really strategic, almost political. He had a choice of appellate courts, the 1st or the 14th District.
Correct. Both cover the 387th court. And the plaintiff didn't just pick one randomly.
No. What was the calculation?
It was based on his prior analysis, something we've touched on before, about the political leanings or affiliations within the Texas judiciary, specifically judges appointed by Governor Greg Abbott.
Okay. Why focus on Abbott appointees?
His research suggested a potential pattern or predictability there. The 14th court had 4 Abbott appointees. The first court had 7, including the Chief Justice, Justice Adams.
So fewer Abbott appointees seemed like the safer bet. He filed on the 14th.
He tried to. He filed on the 14th, aiming for that court. But the system intervened.
What system?
The internal caseload balancing system. It automatically rerouted his mandamus petition from the 14th straight to the 1st District Court.
The one with 7 Abbott appointees, including the Chief Justice.
The very one. Whether that was just random bad luck or something else, who knows? But the result was clear.
What happened at the first court? Did they act quickly?
Not at all. It was like deja vu. He filed the mandamus, filed emergency motions, even a temporary restraining order, paid the emergency fees. Nothing. Radio silence. For over a week, the appellate court just sat on it, took no action whatsoever.
So the same pattern of inaction he saw in the 387th court was happening one level up.
Exactly. It mirrored the trial court's delay tactics perfectly. And this inaction, this is what confirmed the situation, was a true deadlock. The entire state system seemed stalled.
Okay, so the human element failed. Trying to force action through the standard legal channels just hit a brick wall.
Both at the trial and appellate level, yeah, complete stall.
This is the moment the plaintiff turns to the tech. Let's talk about this legal vaccine. What exactly is this thing?
Fundamentally, it's a piece of software the plaintiff developed himself. Its purpose is to test, stress test, and actually generate optimized legal arguments.
Based on data.
Based on a lot of structured data. It's designed to sort of computationally predict and neutralize legal opposition.
And what kind of data are we talking about? What does it eat?
It ingests a huge range. Transcripts of recorded conversations, which, remember, is legal in Texas if one party consents. Transcripts of recorded software demos he gave, emails, all the court filings, like those, 36-page drafts from Morgan Hybner, petitions, everything relevant.
So it takes all this messy human stuff, conversations, arguments, legal docs, and structures it.
Precisely. It structures it, allowing it to do more than just keyword searching. It performs semantic analysis, figures out who's who, entity recognition, and crucially, it can connect the dots.
Connect dots? Like how?
Like linking a statement in an email from months ago to a specific claim in a recent filing, or noticing a pattern in conversational topics. It uses these connections to derive really sophisticated legal arguments and, importantly, predict likely procedural moves by the opposition.
But you said its real power is in the testing process, an iterative loop.
Yeah, that's the core strength. It's not just about generating an argument. It's about making that argument bulletproof through adversarial testing.
Adversarial. How does that work?
Okay, think of it like this. The system can be configured to act like the plaintiff's lawyer. It drafts a motion or a response. But then, and this is the key about it, the plaintiff can flip a switch, essentially, and tell the system, okay, now you are the opponent. You are Morgan Hybner, or Adams Law Firm. Your job is to destroy the document I just created.
Whoa, So the AI attacks its own creation.
Exactly. It generates every possible counter-argument, every procedural loophole, every way to attack that draft. It's like finding the zero-day exploits in your own legal work before the other side does.
So the plaintiff sees the weaknesses the AI found.
Then strengthens the document to patch those weaknesses, and then runs the simulation again and again, sometimes 10, 20, even 30 iterations, until they reach a point where the AI acting as the opponent simply can't find any more significant ways to attack the document.
It becomes unassailable, as the source material calls it.
That's the goal, to have a legal position so rigorously tested and refined that it's practically impervious to attack. It's a huge advantage.
It really shifts legal prep from intuition and experience to something more like data-driven engineering.
That's a great way to put it. Adversarial simulation for legal documents.
So, applying this powerful tool to the situation in early October 2025, what was the legal vaccine's cold, hard assessment?
It confirmed the plaintiff's fears. The assessment was procedural deadlock, complete impasse.
No way out through the state court.
Not effectively. The AI calculated that the appellate court wasn't going to act on the mandamus in time. The 60-day temporary order window was closing fast.
And if that window closed?
The mandamus becomes moot, procedurally dead, meaning the plaintiff loses the chance for state appellate review simply because the system stalled him out.
So the AI recognized the human strategy against him was just run out the clock.
Yep. Delay was the weapon, and the AI confirmed it was working. A different approach was needed, urgently.
Okay, deadlock confirmed by the AI. It recognized that the standard procedural arguments weren't working. It needed a different angle.
Something completely outside the existing fight over the orders and the mandamus.
And this is where the source calls it the AI's brilliant move. It leveraged that deep conversational data it had ingested.
Exactly. It started analyzing transcripts, specifically conversations between the plaintiff and his former partner, and it flagged anomalies, financial anomalies, safety anomalies, things that didn't quite add up.
What kind of details jumped out?
Two clusters of information became really significant when the AI put them together. First, conversations about the former partner's car tires.
Tires, okay.
The transcripts and related evidence indicated they were in really bad shape, like dangerously bad. Metallic mesh showing through the rubber, high risk of a blowout.
Yikes. Okay, what was the second cluster?
Money. The former partner had apparently admitted to racking up huge legal debts over $60,000. Credit cards, a payment plan with Adams Law Firm stretching over 24 months.
60 grand in debt, while driving on dangerous tires.
And claiming she only had about $9,000 in the bank. The AI connected those dots.
The spending priority versus the safety neglect.
Precisely. The AI's logic was cold, purely analytical. It flagged this inconsistency. Someone prioritizing massive legal debt over spending maybe, $2,000, $3,000 on safe tires for the car used to transport their 4-year-old child?
That does raise questions.
Serious questions, the AI concluded, about that person's judgment, their decision-making ability, maybe even their mental state regarding the child's safety.
So the AI saw this not just as a personal issue, but as a potential legal lever.
Exactly. It calculated that this was the vulnerability. This is the key to forcing the appellate court's hand.
But wait, that sounds really aggressive. Using a potential child safety issue, even if it's based on facts like bad tires, primarily as a tool to break a procedural logjam in a totally different court, that feels ethically tricky.
The source material suggests the plaintiff understood that calculation. The primary goal, according to the AI strategy, wasn't necessarily to get the mother declared unfit long-term in that moment.
No. What was the immediate goal then?
To create an undeniable legal emergency, something the appellate court simply could not ignore without exposing themselves to massive liability.
Force their hand through potential negligence.
Right. The AI reasoned. If you present credible evidence of imminent physical danger to a child, backed up by photos and expert opinion on those tires, and the appellate court still does nothing.
And their inaction becomes grossly negligent itself.
That was the calculation. Shifting the liability for delay onto the justices themselves, it was the only way the AI saw to guarantee immediate action.
So the strategy became, forget procedure, allege immediate danger. How fast did they act on this?
Instantly. The AI recommended getting proof. The plaintiff took the car to a tire shop, got photos, got an expert assessment.
What did the experts say?
Confirmed the danger. Said the tires were gone, dangerous to drive with. Gave an estimate for replacement high-end tires, around $2,959. This wasn't just the plaintiff saying it, it was documented risk.
Okay, so he has the proof. What next?
Armed with the photos and the expert, quote, he drafted a new temporary restraining order, a TRO, filed it directly with the appellate court.
Not about the old orders, but solely about this imminent child danger issue.
Correct. Focused entirely on the immediate risk posed by the tires. And he filed it late at night, 11:00 p.m. on Monday, October 13th. The fuse was lit.
Okay, the TRO alleging imminent child danger is filed late Monday night. What happens next? Did it work?
Oh, it worked immediately. It was like flipping a switch.
How quickly?
Just 8 hours later, 7:40 a.m., Tuesday, October 14th, the appellate court issued its ruling.
Wow. After weeks of silence, they respond in hours. What did they rule?
They denied the original writ of mandamus.
Denied it. So he lost.
On the surface, yes, but how they denied it was everything. It was purely procedural. They
Yeah.
used a standard denial form. They didn't engage with any of the substantive arguments the plaintiff had made, not the due process violations in the trial court, and crucially, not the imminent child danger claim he'd filed just hours before.
They just ignored the dangerous tires allegation.
Completely ignored it in their ruling. Their reason for denying the mandamus was simple. They said it was now a moot point.
Moot. Why?
Because, they claim, the temporary orders had already been signed by the trial judge, Judge Telfair.
Wait, Judge Telfair signed the orders. When?
This is the critical discovery, the bait and switch, as the source calls it. The plaintiff checked the 387th court docket online, and it showed Judge Telfair had apparently signed the orders back on October 10th.
October 10th.
Oh.
That's the same day he told the plaintiff in the hearing that the orders were heavily contested and set another hearing for the 16th.
Exactly. It makes no logical sense based on what happened in the hearing, but that docket entry, whether real or backdated or whatever, it gave the appellate court the procedural excuse they needed.
The excuse to say, oh, the orders are signed now, so the mandamus asking us to compel the signing is moot.
Precisely. They could dismiss the whole thing procedurally without ever touching the merits, especially the explosive child safety issue. They only acted after the safety TRO forced their hand, but they used the trial court's convenient docket entry to sidestep the real issues.
Okay, this sounds like a blatant maneuver. But the source says the plaintiff and the legal vaccine saw this denial, this apparent loss, as a huge win. Why? How is losing a win?
Because the goal wasn't necessarily to win the mandamus itself. The goal, optimized by the AI, was to get to federal court.
And this denial achieved that.
Perfectly, by refusing to address the merits, by ignoring the safety claims, and by issuing a purely procedural denial based on a questionable docket entry, the state appellate court effectively proved one crucial thing.
What was that?
That all state-level remedies were exhausted or futile. The plaintiff had tried everything, the trial court, the appellate court, even raising an emergency safety issue, and the state system shut him down procedurally.
And proving exhaustion of state remedies is the key.
It's the legal key you need to unlock the door to federal court for a Section 1983 civil rights lawsuit. The state system, by its own actions or inactions, just handed the plaintiff that key.
So the AI didn't just predict the denial, it engineered it. It used the safety TRO as bait to force a specific type of dismissal.
That's the interpretation. A calculated procedural loss in state court to guarantee the necessary predicate for a federal win. It's high-level legal chess.
Which brings us to this fascinating clerical mistake hypothesis the plaintiff developed. It sounds like a way to explain the inexplicable October 10th signing.
It is. It's a hypothesis designed potentially to provide plausible deniability for the judges involved while still acknowledging the outcome.
Okay, break it down. What's the hypothesis?
It suggests that maybe Judge Telfair didn't actually sign the full orders on October 10th, despite what the docket says.
So the docket entry, Index 81, is wrong.
The hypothesis proposes it might have been a bogus entry or a simple clerical mistake. Maybe a court clerk created the entry incorrectly or backdated it or entered something generic.
What's the strategic benefit of blaming a clerk?
Plausible deniability all around. If it was just a clerk's error, then Judge Telfair didn't necessarily lie about the contested hearing on the 16th. And the appellate justices weren't necessarily acting on a falsified record. They were just acting on what the official docket showed, even if it was wrong.
So liability shifts from the judges to a potentially anonymous clerk.
Potentially, yes. It protects the key players while achieving the necessary outcome, getting the mandamus dismissed procedurally before the court had to rule on the child danger TRO.
Is there any evidence supporting this clerical mistake idea?
There's one intriguing detail. The docket summary for that Index 81 entry, the supposed signed order, it apparently listed the document as being only 3 pages long.
3 pages. But Morgan Hybner's contested draft was over 30 pages, and the plaintiff's was 1.5.
Exactly. 3 pages doesn't match either of the main drafts. It's possible the judge signed the plaintiff's short version, but that seems unlikely given the conflict.
Or the 3-page entry wasn't the actual order at all. Maybe just an administrative notice mislabeled as the order.
That fits the hypothesis. A simple 3-page filing notice gets entered, maybe incorrectly dated, and boom, the appellate court has its mootness excuse. The critical point is, regardless of how it happened, the procedural dismissal was secured, paving the way.
The AI predicted the state appellate denial. So the plaintiff was ready. You're saying he drafted the entire federal lawsuit before he even got the denial?
Yes. The legal vaccine's prediction was that strong. He drafted the complex federal complaint on Monday, October 13th, fully expecting the denial to come through on Tuesday.
And the speed of filing after the denial? That was remarkable.
Astonishing, really. The denial email arrived at 7:40 a.m. on Tuesday the 14th. The federal lawsuit was physically filed by 1:00 p.m. the same day.
Wait, physically filed? Why not e-file?
According to the source, his e-filing privileges had been revoked, so he had to make a 3-hour round-trip drive to the federal courthouse to file it in person.
Okay, let's process that. Denial at 7:40 a.m., leaves immediately, drives an hour and a half, files a massive complaint, drives an hour and a half back. All done by 1:00 p.m.
Less than 5.5 hours from denial to filed, including a 3-hour drive. It means the entire federal complaint, a complex 42 U.S.C. Section 83 action, was fully drafted, vetted, printed, and ready to walk into the courthouse the moment that denial arrived. That's next-level preparation, driven by the AI's predictive accuracy.
Incredible. So this case, Aguirre Marcano v. Rivera Hybner, case number 4.25 CV04890. Filed in the Southern District of Texas, assigned to Judge David Hybner. What's the core allegation?
It's a federal civil rights lawsuit under Section 1983. That law lets people sue state officials or anyone acting under color of state law if they violate constitutional rights.
And the specific right violated here?
Primarily due process under the 14th Amendment. The plaintiff, who is also a recognized political refugee, alleges there was a coordinated conspiracy involving state actors.
The conspiracy to do what?
To weaponize the Texas family court system against him, to obstruct justice, and ultimately, he alleges, to facilitate the kidnapping of his son, all under the guise of legal proceedings.
Heavy charges. Who are the main defendants named in this federal suit?
Morgan Taylor Rivera Hybner, the attorney from Adams Law Firm, who drafted those allegedly fabricated orders, is a key defendant, sued individually and officially.
And the firm itself?
Adams Law Firm, PC, is also named, but it goes beyond the lawyers.
Right, because it's a Section 1983 claim. It has to involve state actors.
Correct. So, Fort Bend County, Texas is named as a defendant. And critically, Sheriff Eric Fagan is sued in his official capacity.
Official capacity. Why is that distinction important? Suing the sheriff himself versus suing his office?
It's crucial for bringing the county in. Suing Sheriff Fagan in his official capacity invokes something called Monell liability.
Monell liability. Explain that.
Under Monell, you can hold a municipality or county liable if their official policy or custom led to the constitutional violation. It's not just about one rogue officer. It's about the system. So, by suing Fagan officially, the plaintiff is arguing that the alleged actions weren't isolated incidents, but reflected a pattern or policy within the sheriff's department, making the county itself liable.
Okay, so who are the specific officers named that provide the evidence for this alleged policy or custom?
2 deputies are named. First, Deputy Bell, badge number 4355.
What's the allegation against Deputy Bell?
The suit alleges Bell coordinated with the former partner before she even called 911, and worse, Bell allegedly told the partner about a hypothetical statement the plaintiff made something about possibly picking up the child from preschool the next day.
And the consequence of Bell revealing that?
Hours later, the former partner contacted the preschool and placed the child on indefinite leave, effectively preventing the plaintiff from seeing him there. The suit presents this sequence, the deputy's communication, directly leading to the child being removed from school as direct evidence of state actor coordination to obstruct custody.
Wow. Okay, who was the second deputy?
Deputy Walker, badge number 40097. The allegation against him involves a separate incident with an unidentified process server listed as John Doe 1.
What happened there?
Walker allegedly refused to file a trespassing report against this process server. And during the encounter, Walker's patrol car license plate was reportedly obscured.
Obscured license plate, refusal to file a report. What does that suggest?
The suit presents it as part of a pattern. suggesting potential complicity, a lack of accountability, or even deliberate evasion within the department, reinforcing the Monell claim against the county. These aren't just individual errors, they're examples of the alleged systemic problem.
And the ultimate goal if this federal suit succeeds, the plaintiff mentioned using the damages.
Yeah, he's been clear about that. Any damages awarded from the federal lawsuit, he plans to put directly into a fund for his child's college education.
So turning the cost of the legal battle back onto the opponents to benefit the child.
Effectively using money from them, as he put it, to secure the child's future, regardless of what happens in the state case. It's a strategic and, well, deeply personal endgame.
Now, this technology wasn't just used for court strategy. The plaintiff developed a related system specifically to counter psychological tactics, the anti-manipulation pipeline, or AMP.
That's right. It's described as a merge system, combining elements of the legal vaccine with another system called KOL vaccine. Its focus is different, though. It's about detecting and defeating psychological manipulation in conversations.
How does it do that? What's it looking for?
It excels at identifying recurring conversational themes or topics that suddenly appear out of nowhere, especially ones that seem designed to hit a known vulnerability.
So it analyzes conversations for suspicious patterns.
Exactly. It takes unstructured talk phone calls, recorded demos, anything verbal, turns it into structured data, and then flags patterns that suggest targeted manipulation. It's looking for the opponent's attack vectors in everyday conversation.
The source gives a couple of really specific examples of this, suggesting the opponents were actively using the plaintiff's own words against him, like A/B testing psychological attacks.
That's the implication. The first one is called the college play.
Okay, what was that?
So the plaintiff had apparently said publicly, maybe in a demo, that his main goal was never to financially harm his son, Sebastian. He wanted to protect his future.
A natural sentiment for a parent.
Right. But the AMP system flagged that suddenly the former partner started bringing this up repeatedly in conversations. She would apparently start crying and saying things like, all this money on lawyers, you've spent all Sebastian's college money.
Wow. Directly weaponizing his stated desire to protect his son's future.
Precisely. The AMP flagged it as manipulation because it was a new, recurring, highly emotional topic seemingly designed to guilt him, to coerce him into dropping his legal defense to save the college fund he himself cared about.
That's insidious. What was the second example? The attorney fee harassment.
This one is maybe even more direct evidence of using his words against him. The plaintiff had mentioned in other public demos a specific fear or frustration. Having spent $30,000 paying a $500 hour lawyer in a previous case against someone else.
Okay, so he articulated a specific financial pain point from his past?
Yes. And then what happens? Morgan Hybner, the opposing counsel in this case, files a document claiming her legal fees have now exceeded. Guess what?
Over $30,000.
Over $30,000. And her hourly rate, $450 an hour.
It's almost exactly the scenario he described fearing.
It's incredibly close. The AMP flagged this as highly suspicious. Not likely a coincidence, but a targeted tactic designed to trigger his previously stated financial anxieties. Using his own public data against him is psychological warfare.
But there's an irony here, right? This attempt to use high legal fees to intimidate him, it backfired.
Completely boomeranged, according to the analysis, because now, in the federal lawsuit, the plaintiff is pointing to those massive legal fees being incurred by the petitioner.
Who claimed she only had $9,000 in the bank.
Exactly. So the question becomes, who is actually funding this extremely expensive litigation on her behalf? Where is the money coming from to pay Adam's law firm tens, potentially hundreds of thousands of dollars?
The attempt to financially intimidate him created a huge vulnerability for them in the federal case. They now have to explain their own funding.
Their own weapon created a weak spot. It highlights the core principle behind both the legal vaccine and the AMP, transforming everything, court filings, phone calls, offhand remarks in demos, into structured contextual data, then analyzing that data to find patterns, predict moves, and identify vulnerabilities, whether procedural or psychological.
And the plaintiff believes his opponents, this network he refers to, use similar methods.
Yes, he explicitly states he believes they operate similarly, processing information systematically, perhaps on a much larger planet scale basis. The AMP and legal vaccine were developed, in part, as a necessary countermeasure, fighting fire with fire, using structured data analysis to defend against structured data attacks.
Beyond procedural and psychological tactics, these AI systems started flagging potential connections, right? Things that might hint at a broader coordination or conflicts of interest.
Yeah, the system wasn't just looking at the direct case. It was clustering names, dates, relationships across all the data it had. And a couple of potential familial links popped up as statistically significant hypotheses.
Okay, what was the first one? It involved the judiciary.
Right. The system flagged the last name Adam.
Adams, like Adams Law Firm.
Yes, but also Chief Justice Adams of the First Appellate Court, the court that handled the mandamus, the one with 7 Abbott appointees.
So Chief Justice Adams and William Kyle Adams, the owner of Adams Law Firm, Morgan Hybner's boss. Same last name.
The AI flagged that potential connection. Now, it could be a coincidence, obviously, but the system gave it weight because it co-occurred with another piece of data.
Which was?
A conversation where Morgan Hybner reportedly told her client she could not personally handle the appeal. She had to delegate it.
Why would that be relevant?
The hypothesis generated was, perhaps Hybner knew about a potential familial link between her firm's owner, Adams, and the Chief Justice, Adams. By delegating the appeal, the Adams law firm name wouldn't appear directly on the appellate filings in front of the Chief Justice, potentially obscuring a conflict of interest.
So the AI is inferring motive based on co-occurring data points, the shared name, and the delegation of the appeal.
It's generating a testable hypothesis based on correlations in the data. Fascinating stuff.
What was the second potential connection the AI flagged? The Molero-Pajamas hypothesis. This sounds a bit more speculative.
It is flagged as more speculative, definitely. But again, it's rooted purely in recurring textual patterns identified by the anti-manipulation pipeline.
Okay, what was the pattern?
The system noticed the former partner repeatedly, almost insistently, mentioning in conversations that she and her sister were the only 2 female children in their family.
Just repeating that phrase. Only 2 female children.
That specific phrase, recurringly. The AI flagged this repetition as statistically unusual. It then clustered this with some much older anecdotal data points from years ago involving matching pajamas.
Matching pajamas. How does that fit in?
Apparently, there were mentions of the partner and someone named Harold Martinez wearing matching pajamas, and separately, someone named Patricia Rojas and the Moleros wearing matching pajamas. Molero is the former partner's maiden name.
Okay, so where does the AI take this?
The hypothesis generated is the insistence on only 2 female children might be a deliberate verbal smokescreen to hide the existence of a male sibling. Perhaps a brother named Daniel Molero who was never mentioned?
Why would hiding a brother be important?
The speculation is that obscuring certain familial ties, particularly to male relatives potentially connected to this network, might be strategically important to the operation. It's about hidden connections.
So the AI is literally analyzing conversations for what isn't being said or what's being said too emphatically.
Essentially, yes. Looking for signs of systematic conversational editing or omission. It highlights the power, but also the almost intrusive nature of this analysis.
Which brings us back to the ethics of the legal vaccine itself. It's incredibly powerful.
Undeniably. And the analysis points out its fundamental nature. It operates with a kind of cold pragmatism.
A lack of moral fiber, as the source puts it.
Yeah, it acts like a hyper-aggressive lawyer, purely optimizing for the win. When it recommended using the tire issue, the child safety angle, it wasn't making a moral judgment.
It just saw it as the most effective tactical move.
The most effective path to the goal, which was unlocking the federal court. The AI calculated that challenging the mother's fitness on that specific, verifiable point was the quickest way to force the appellate court's hand, even if a human lawyer might find that tactic deeply uncomfortable or ethically questionable as a primary strategy.
So the human using the tool is paramount. The AI provides the options, but the human has to make the call.
Absolutely critical. The source material stresses this. The power of this technology means the human operator must have a strong moral compass.
Because the AI itself doesn't, it just optimizes.
Right. It will find the most ruthless, effective path based on the data. Without strong ethical constraints imposed by the human user, the legal vaccine could easily become, as the source warns, a dangerous weapon used for chaos, oppression, or purely destructive ends. The human provides the conscience the machine lacks. #outro.
Well, this has been quite the deep dive. We've traced this journey from a complete procedural deadlock in the Texas state courts
Total obstruction, really. Using the rules to prevent justice.
to the deployment of the legal vaccine. The AI identifying that crucial tactical vulnerability around child safety,
The tires, yeah. The key that unlocked everything.
which then led to that strategic, almost engineered procedural denial from the appellate court.
The denial that seemed like a loss but was actually the victory, because it satisfied the prerequisites for the federal case.
And culminating in that rapid filing of the major federal civil rights lawsuit, it's an incredible sequence.
It really demonstrates a fundamental shift, I think. When you face systematic weaponization of procedure, maybe by state actors, maybe by large firms.
The old ways might not be enough.
Exactly. The defense might require this kind of highly technical, data-driven analysis to predict, to preempt, and sometimes to force open doors to justice that traditional methods just can't unlock anymore. It's a glimpse into the future of law, where data science meets litigation head-on.
A fascinating and maybe slightly unsettling glimpse.
Indeed. And just one final thought for you, our listener, to chew on, something from the source material we didn't fully explore. The plaintiff apparently concluded that the reason his federal filing wasn't intercepted, despite his belief the opposition had significant surveillance capabilities, might have been because of his browser choice.
His browser, like Chrome or Firefox.
He hypothesized that the main vector the opposition used to monitor him might have been specifically the Google Chrome or Chromium browser infrastructure, and by avoiding it for critical tasks, he evaded interception.
Wow, so think about that. How seemingly small tech choices, the browser you use, whether you trust e-filing systems in a hostile environment, could have massive implications for your personal security and your ability to operate strategically against sophisticated adversaries. Something to consider.
Definitely something to consider.
We'll see you next time for another deep dive.